Good afternoon, everybody. Thank you for joining today's AIR Forms Practitioner webinar. A brief introduction about me. I'm the managing partner of Consensus Legal. At Consensus Legal, we focus on commercial sales, leasing, and financing transactions. You're here to hear about and discuss AIR CRE contracts, and in particular, two of the leases. As you probably know, these are very well drafted real estate contracts. Using them makes transactions more efficient and easier to complete. And in my opinion, nationwide, these are the best contracts out there. A couple of disclaimers before we begin. AIR Forms Practitioner is not affiliated with or sponsored by AIR CRE. I'm not providing legal advice during these webinars. It is for education and discussion purposes. So for today's 20-minute webinar, we will focus on repair and maintenance obligations in the single-tenant net lease versus the single-tenant gross lease. So we're not going to discuss the two or the multi-tenant leases today. That'll be the topic for another webinar. Today, it's these two single-tenant leases. And this topic, it sounds maybe a bit mundane to some people, but there are major economic consequences for both lessors and lessees in these provisions. So the format, as always, is 20-minute webinar. During the 20-minute webinar, you can post questions in the chat box. I may not be able to get to them during the 20 minutes, but I will stay on after the webinar for questions and answers. Okay, so hopefully you can see it on your screen, the single-tenant net lease, and I have it on paragraph 7. So just to orient ourselves before we discuss these specific provisions, Paragraph 7 in the AIR CRE leases relate to lessees and lessors repair and maintenance obligations and some other items. But today's webinar, we're going to focus in particular on 7.1 lessee obligations and 7.2 lessors obligations. Okay. And so this is, as I mentioned, the single-tenant net lease. So we're actually going to go backwards in this lease. We're going to start with 7.2 because I think it's easier for all of us to understand if we go bottom to top. So we're going to start with lessor's obligations. So this is the single-tenant net lease, and the key provision here, which we all should be aware of, is right here. It is intended by the parties hereto that lessor have no obligation in any manner whatsoever to repair and maintain the premises or the equipment therein, all of which obligations are intended to be that of lessee. So this is absolute in any manner whatsoever. So this is the net lease. And now let's flip to the gross lease and compare what the gross lease says in 7.2. So this is the same provision, 7.2. It's a little longer. It's 5 lines, you can see here. And it starts out the same. It is intended by the parties hereto that lessor have no obligation in any manner whatsoever to repair and maintain the premises or the equipment therein, all of which obligations are intended to be that of lessee. So it starts out the same, but then it has this key provision, except. And what's the exception? The exception is the surface and structural elements of the roof. That's the first exception. So it's not just the structure of the roof, It's the surface. So that would be the roof membrane. So the roof is lessor's responsibility in the gross lease. But then it goes on to describe foundations and bearing walls are also an exception. So generally speaking, the exceptions in the gross lease where lessor is responsible are structure and the roof. Okay, so that's the gross lease, and that's the key difference in lessor's responsibility in the gross lease versus the net lease. So now I have flipped back to the net lease. We've gone over this general rule, but I'm going to hit you with a pop quiz. So it says lessor has no obligation in any manner whatsoever to repair and maintain the premises. Does lessor have any replacement obligation in the net lease, single tenant net lease? The answer is yes. Lessor does have a replacement obligation, and that replacement obligation is described in 7.1D. So this provision says that if an item described in paragraph 7.1b cannot be repaired other than at a cost which is in excess of 50% of the cost of replacing such item, then such item shall be replaced by lessor. So in a few moments, we'll get to the items described in 7.1b. But for now, the concept is if there are certain items that cannot be repaired at a cost which is in excess of 50% of the cost of replacing, then lessor is obligated to replace the item. Okay? But lessor's not solely responsible for that expense. The cost is actually shared and prorated between the parties. And it's amortized over, if you look at the end here, it's amortized over 12 years. So it says 144 per month. So if an item is replaced, lessor initially pays the cost, and that cost is amortized over 12 years. So if there are 6 years left in the lease term, then lessee is only going to end up paying 1/2 of the cost of the replacement. Yeah. Okay. So, so that's the replacement obligation. Now, the key provision is what items are we talking about that are subject to lessor's replacement obligation? And it's the items described in 7.1b. What are those items? So 7.1b relates to service contracts that lessee is required to procure and maintain. And there are 6 items specifically for which lessee has to procure service contracts. So it's HVAC equipment is 1, boiler and pressure vessels, fire extinguishing systems, including fire alarm and or smoke detection. Number 4 is landscaping and irrigation systems. Number 5 is roof covering and drains. And 6 is clarifiers. So if any of these 6 items needs to be replaced, then lessor replaces it. It pays the cost, and then that cost is prorated over 12 years, and lessee has to pay its share during its lease term. So if there's 4 years left in the lease term, it's amortized over 12 years, lessee is only going to end up paying 1/3 of that replacement cost. Now, let's flip back to the gross lease. The gross lease has the same concept, replacement, the same 50% threshold for replacing, and the same 12-year, 144-month amortization period. So it's the same concept in the gross lease, but there is one key difference in the replacement obligation, and that is in 7.1b, because the items that are being replaced are only the items listed in 7.1b. In the single tenant net lease, that list is 6 items long. In the single tenant gross lease, the list is only 5 items long. And the difference is, flipping back to the net lease, I'm sorry, number 5 is roof covering and drains in the net lease. And you'll see in the gross lease, roof covering and drains is not there. So with respect to the roof membrane, that item is not split between the parties in the gross lease. And if it does need to be replaced, if the roof membrane needs to be replaced, lessor is not shifting some of that cost over 12 years to lessee. And why is that? Does anyone know why? Why is there a difference here in the gross lease and the net lease with respect to replacement?
The landlord's already taking care of the responsibility of the roof.
Exactly, David. Because in the gross lease, lessor is, I thought I was going to stump you, David, with that one. Because lessor is responsible in the gross lease for, in 7.2, for the surface and structural elements of the roof, if it needs to be replaced, it cannot shift the cost to lessee. Okay? So we've gone backwards from 7.2 up, and we've kind of talked about it from a lessor perspective. Now, let's shift a little bit, going back to the net lease. Let's talk about 7.1, lessee's obligations. In general, as you may suspect, lessee's obligations are basically everything else. So we described lessor's obligations to repair and maintain. We talked about lessor's replacement obligation, lessee's obligations for repair, maintenance, replacement is everything else, basically. So this key provision here in 7.1a, lessee at lessee's sole cost and expense. Lessee shall, at lessee's sole cost and expense, keep the premises, utility installations, and alterations in good order, condition, and repair. So that's the general overriding kind of obligation here. And this parenthetical is clarifying and is an important point to discuss. Whether or not the portion of the premises requiring repairs or the means of repairing the same are reasonably or readily accessible to lessee, and whether or not the need for such repairs occurs as a result of lessee's use, any prior use, the elements, or the age of such portion of the premises. So, for example, lessee moves into a premises 4 months after the commencement date, a plumbing line ruptures, and that plumbing line is behind a wall or under the slab, lessee is responsible to fix it, even though it's behind a wall, for example. And what if that plumbing line is 50 years old and it didn't burst, it didn't rupture because of anything lessee did, but just because it was really old? This parenthetical clarifies that lessee is responsible in such situation. And then the AIR lease goes on to give including but not limited to list of these things that lessee is responsible for: plumbing, HVAC, electrical, lighting facilities, fire protection, fixtures, walls. This is the net lease: foundations, ceilings, roof drainage systems, floors, windows, doors, plate glass, skylights. And then you'll see here, it also describes exterior areas: landscaping, driveways, parking lots, fences, retaining walls, sideways, parkways, etc. So if the definition of the premises, and it oftentimes does in these single tenant leases, if it includes exterior areas, this clarifies that lessee is responsible for those areas as well. This sentence is also notable. Lessee's obligations shall include restorations, replacements, or renewals when necessary to keep the premises in good order, condition, and repair. So it's clarifying that just replacement is included. And then finally, this is something that a lot of people aren't aware of, but it can have economic consequences. Lessee is also responsible for exterior repainting of the building. Okay, so that is the net lease. And in these last couple minutes, we're just going to flip over and talk about the provision in the gross lease. This is the gross lease. The gross lease is almost identical to the net lease in terms of lessee's obligations. You'll see a lot of it. It looks the same. It is the same. One of the differences is here. This just clarifies: lessor shall keep the surface and structural elements of the roof, foundations, and bearing walls in good order, repair, and in good repair. And it references paragraph 7.2. And lessee is also responsible for exterior repainting of the building. So we're just about at that 20 minutes. I'm going to mention just a couple of details that we'll get into. So in the flipping back to the single tenant net lease, this last sentence of the single tenant net lease in the replacement section: once lessor pays the cost of replacing an item and it's amortized and charged back to lessee, it also provides that lessee shall pay interest on the unamortized balance. So it's not just passing through the cost. Lessor can also charge interest. And what is the interest rate? Anybody know the interest rate under the AIR lease? I'll go to it. 13.5, the interest rate is 10%. Okay. So I will stop there. And I'll look at the chat box for questions. First, Mark asks if there is only 1 year left on a lease and you replace an item to be amortized over 144 months, can that cost be carried forward to the next tenant? A good question. So, first of all, that 1 year, the existing lessee will pay 1/12 of the cost. And yes, Mark, that cost can be carried forward to the next tenant, but that's subject to negotiation and agreement between the parties. Um, because that item was replaced before the new tenant's lease term commenced, then and it's not replaced during the new tenant's lease term, it's not automatically passed through to lessee during the new lessee's lease term. That's my understanding. Pretty sure about that. I'd have to double check, but pretty sure. Um, Steve asks, who will determine the costs value of those items to be replaced? That's a good question. It doesn't state who determines that 50% threshold that triggers replacement. It doesn't state whether it's lessor or lessee that determines it. So there is a possibility that there can be disagreement by the parties. If lessor says it does need to be replaced, it's over 50%, lessee might disagree. And typically those disagreements are resolved. But if for some reason it couldn't be resolved, then I guess it could be resolved by a court. How about if lessee renews the lease? That's a really good question. And I think that question relates to that replacement obligation. If you're amortizing it over 12 years, you have 1 year left in that lease term. So the lessee is only paying 1 year, but then 6 months before that term expires, lessee exercises a 5-year option. And in that scenario, that obligation to pay 1/144th every month would continue. So instead of lessee paying for 1/12 of that replacement, it would end up paying for 6 years of it, 1/2 of that replacement. Excellent question. John asks, what about property management fees? So that is a good question, really good question. It doesn't relate necessarily to repair and replacement, but that is in these single tenant leases, there isn't a specific provision to pass through property management fees. Really good point, economic point, John. David asks, how do we determine normal wear and tear upon the vacating of lessee? Yes. Thank you for reminding me about that question. There is no elaboration. There's no specific definition of what wear and tear means. That definition doesn't exist in the AIR CRE leases. And I will also say, David, that even in custom attorney drafted leases, even one's institutional leases that are 70, 80, 90 pages, you won't see typically, I don't recall seeing that definition even in those leases. So it's something that, the parties just have to figure out. And are there disputes? Yes, there can be disputes about it, but so that's not the best answer for you, but you all are real estate professionals. You probably know better than the lawyers drafting these leases, kind of what's normal wear and tear. Spencer, so if we want a true single tenant gross lease, i.e. only a lump sum monthly, do we need to strike these items in 7.1 and 7.2. So you're talking, I think, Spencer, about maybe a full service gross lease that we sometimes see in the office context. I believe that's what you're referring to. And a lot of people don't know this, but the AIR has office leases. But oftentimes, if it's a single tenant lease of an entire office building, these single tenant leases are used. And I guess the answer, Spencer, would be yes, if the desire is to shift the repair and maintenance responsibilities entirely to lessor, then yes, these provisions would need to be revised. Hector asks, what is something you would recommend crossing out if you were lessee before signing a lease agreement to protect yourself? So one of the things that's a good question. One of the things that is sometimes negotiated by lessees is the amortization period of 12 years. It's sometimes negotiated by lessors also. Lessors want to shorten that amortization period sometimes, and lessees sometimes want to increase that period. So that is sometimes negotiated. The general lessee obligations are pretty common. In the net lease, sometimes lessees want to security for the roof to lessor. So that's an item. But in terms of the lessee's obligations in 7.1, those, it's typically not heavily negotiated because in commercial leasing, it's this 7.1 is a pretty typical type of allocation of the general responsibilities of lessee. Christina asks, when an OM states in a Starbucks single tenant net lease that landlord has absolutely no responsibility, is it really absolute? Wow, we're getting very specific there. Starbucks leases are their own, typically Starbucks uses a custom lease. They will not typically use an AIR CRE lease. Maybe you can follow up with an email, Christina, so I can get more detail on that question. Another question, if a palm tree fell on the roof of a multifamily building, who will be responsible for the repairs? That is a good question. And that probably relates to casualty, the casualty section of the lease, as I'm thinking about it, damage destruction, more than kind of repair and maintenance. So that's a bit outside the scope of this webinar. Herb asks, I have been using the multi-tenant net for single tenant net leases so that I can charge the management fees. Yeah, interesting point. In the multi-tenant, property management fees are explicitly permitted to be passed through. And W asks, if you sell your property and the tenant is still reimbursing for an HVAC replacement, can the buyer continue to collect from lessee? Yes, the buyer steps into the shoes of lessor, and as if nothing really happened between the parties. It's just replacing one entity or one party as the lessor with another. So the lease would continue in full force and effect, presumably. Mike asks if a replacement is completed and during the time of the amortized payments, the unit needs to be replaced again, and the unit is out of the warranty stage, can two amortized charges be billed to lessee? I've never seen that happen, but I don't see why not. Okay, so those are the questions in the chat box. There's one more item that I will get to since we have a little bit of time. And let me go back and sharing this is again the single tenant net lease. So we talked about in the single tenant net lease, there's no maintenance, repair and maintenance obligation under 7.2. There are, if you notice this initial phrase, it says here, subject to the provisions of paragraphs 2.2, 2.39, and 14, it's intended that lessor has no obligation. So there are some limited situations other than what we've discussed where lessor would have a repair obligation. 2.2, for example, is what I refer to as the premises warranty. In the first 30 days after the start date of a lease, lessee has an opportunity to report some matter that is not working. And in that 30-day period, if it's reported to lessor has an obligation in general to fix that matter. The warranty period is 6 months for the HVAC. So that is a scenario at the beginning of the lease term where lessor would be obligated to repair an item. 2.3 relates to changes in applicable laws, where the law changes and maybe in California, for example, there might be earthquake retrofitting required. 2.3 relates to the parties' responsibilities in a situation where there's a modification to the premises that's required by applicable law. Damage and destruction, lessor could have obligations if there's damage or destruction to repair. And same with condemnation. There are circumstances where lessor could be responsible. But in general, of course, except in those kind of, unusual, I guess 2.2 isn't that unusual, but in general, this obligation is really limited. Lessor has virtually no repair and maintenance obligations except in those limited circumstances. I wanted to wrap up. Just thank you again for your participation. Really enjoyed seeing you all. The next webinar will be on the multi-tenant leases and comparing repair and maintenance obligations in those leases. Thank you again. Nice seeing you all. Have a great day.